51-year-old man with his first felony conviction. Started as a deferred judgment and sentence and was based on a series of communications with the public that were open to the judge, that were threatening in nature, violent in nature, and that frightened the judge. With respect to the harm in this case, the closest analogy I could possibly present to so people understand the harm to the victim is Bonnie's Law, the stalking law. And in the General Assembly's sort of exposition with respect to stalking laws, one of the things that they talk about is how stalking behavior means that a victim is not safe anywhere. Not only does it remove their sense of anonymity or security in places as benign as a grocery store or a stoplight or a bus stop, but it removes the sense of safety in someone's home. As the court is aware, Mr. Brandt obviously is an activist and cares very much about constitutional rights. One of the constitutional rights that is most guarded is the sanctity of the home. We saw that, I think, in the Kylo case with that speaking device that the Supreme Court said was inappropriate because it violated the sanctity of the home. This conduct, while words and while threats that were not acted upon, violates the sanctity of the victim's home. It violates her sense of security and safety no matter where she goes. And that is really unfortunate no matter who you're talking about, right? It doesn't matter the personal characteristics of the victim. The fact that someone's robbed of a sense of enjoyment in their life is problematic. In this particular situation, it is particularly problematic or particularly pernicious because of the characteristics of the victim. Judge Delgado is a public servant. She worked in Boulder County as a district attorney, and she worked in Adams County as a judge for quite some years. She's not, she is a minority woman. She is small in stature, and she is big-minded. That is to say, she actively engages with problem-solving courts. Judge Delgado is not the problem in the system. I'm not going to stand before this court and tell you that there aren't problems in the system, that there aren't reasons for protesters and for actions like Mr. Brandt, has called for, or changes that Mr. Brandt has called for. I fully admit that we can always do better. We always should do better. But judges like Judge Delgado, who speak a new way, who speak a different way, who engage in mental health court, they're not the problem. And so there are sort of two issues in terms of victim impact with this offense. Not only generally what is taken from a person, but in particular this person, a public servant committed to making sure that we all live in a better place. I know the court, and as the court has been with me on this case with all of us since the very beginning, and in fact sat through the co-defendant's trial. I usually like to start my sentencing arguments by sort of previewing my ask or my prayer. In this case, I'm not asking for prison. In this case, I'm asking for community-based supervision. And I want to make that clear up front, in not only so that the court can sort of hear my words in relation to that, but I also think it's necessary to address what I think would be disparate treatment between co-defendants. As the court is aware, Mr. Brandt wasn't charged in a vacuum. He was charged together with a co-defendant, Adrian Brown. I don't think the cases were ever formally joined, and that is likely to do with the fact that there were differences in conduct. Mr. Brandt engaged in unfortunate, threatening words on the internet, on a Facebook page, and then he picketed outside of the courthouse with an effigy of Judge Delgado hanging from a noose. Adrian Brown was in a different position in a couple of ways. One, not only was he personally threatening, that is to say, in close proximity to the judge, but he was also up on her bench. mere photographs of her family, and making threats that appear to be related specifically to those photos. While Mr. Brandt obviously was appearing before this court on his first felony, Mr. Brown was subject to be stricter to the two prior felony rule, given a very long criminal history, some of which was violent. Specifically, the most concerning offense I think of was an offense with a knife, a menacing incident with a young lady that felt unsafe and frightened for her life at the hands of Mr. Brown. So I wanted to acknowledge that I am advocating for disparate treatment between what I perceive to be co-defendants. With respect to other things I think the court should consider, the court is aware that Mr. Brandt has been on a deferred judgment and sentence with a diversion program in Jefferson County. His client manager is a man named Aaron Moon. Mr. Moon couldn't be here today because of some personal tragedy, but I did ask him, what is the issue here? What could we do better? What does Mr. Brandt need? Several jurisdictions have obviously reached out to him to try to figure out, is Mr. Brandt compliant? Is he disruptive? Does he yell? Is he profane? None of those things. In our time supervising Mr. Brandt, he has been polite, he has been appropriate. Not only has he engaged in treatment as we've requested, but he actually signed himself up for more treatment because he was excited about those opportunities. When I talked to Mr. Moon about, what is left, what else could we do, his suggestion was mental health. It's unfortunate, I know we have looked at veterans court, both in this jurisdiction and Jefferson County, and I think while Mr. Brandt was accepted for veterans court in Jefferson County, there's no mechanism to sentence him to veterans court here to be supervised in Jefferson County. I did look into that. Adams County did deny him, and I think there's probably a lot of reasons for that. I wasn't privy to that process, but it's rather unfortunate because a problem-solving court like that with a higher level of supervision that focuses on the deficiencies or the issues, specifically with that funding piece and that piece related to veteran-specific treatment, would be so helpful. But we're not, unfortunately, going to see that. With respect to the personal characteristics of the offender here, obviously I've already gone through the offense itself. Mr. Brandt presents as a veteran. I think that's significant. He is a man who served his country. When he returned to, I guess, civilian life, he was plagued by a homelessness. Whether, it's a chicken and egg situation, I don't know what beget what, but we have a pattern of homelessness, drug abuse, and mental health issues. And then a history of trauma, personal trauma for Mr. Brandt in terms of his prior relationships. More than that, Mr. Brandt sits before the court, a man who is a minority in the sense that he's a homosexual man. And I bring that up because I think that all of these personal characteristics go to the heart of the case. We have a man who has some mental health issues, a man who doesn't think and feel like everyone else, a man who committed himself to the service, to the armed service, for the benefit of other citizens. And he came back and he experienced hardship. And people who experience homelessness, people who experience hardship, are often invisible. And it doesn't mean that, someone like myself or the rest of society, is meaning to do any harm. It's easier to look away. But when you're voiceless and you're unseen and you feel different than, and you're suffering from mental health issues, and you've given to your country and received sort of no acknowledgement or return investment, that can be difficult. And so Mr. Brandt did something that I'm not particularly surprised about, is after becoming unseen, he became angry, and he engaged in protesting behavior. He became a voice and a spotlight for abusers of power, for other folks who are unseen, that those people mattered, that they should be seen. And I think all of that is fair and right and good. In our country, we have a long history of protesters, and they change the world for the better every single day. The issue came when Mr. Brandt, I think, ironically became the very thing he was fighting against. And here's what I mean by that. There is sort of that old adage or sense that in humanity, because of human nature, the oppressed often becomes the oppressor. And in this situation, Mr. Brandt had fair criticism about people in power. And he called out abuses of power. And as he did that with success, that is to say, he was charged, and he didn't do what many other people do. Because when people protest, when they stand up, when they say this isn't okay, this isn't right, they pick up petty offenses. They pick up low-level misdemeanors. They pick up cases where the offer is 2 days credit time served post the case. And most people take that. Most people acknowledge some fault and they take the offer. It happens every day across the country. But Mr. Brandt, for reasons outside of himself, based on a warrior spirit, a commitment to not being unseen, said, I'm not going to do that. I'm going to subject myself to months and months of bond conditions and a fight. And I'm going to stand up and I'm going to say this isn't okay every single day. And I'm going to do it because it's the right thing to do. And he did that. And he did it over and over and over again. I made a list of all the cases that were dismissed. And I think the court can see that in the PSI. It is a long list. It is a profoundly long list. And while we see a list of cases in black and white, letters and numbers, and the word dismissed, it's a lot different to read that than to live that. Because every time he came into a courtroom, there was a chance he didn't leave. Every time he came into a courtroom, there was a chance he'd sit in a jail cell, that he'd go to prison, that he'd miss family, that he'd miss friends. But he did it anyway. And all of that is brave, and all of that should be applauded. The issue came with Mr. Brandt's success. From my perspective, Mr. Brandt, by standing up and succeeding, received a number of things, to include fear and respect from those in power, and also monetary judgment. And when we experience success as humans, as people, there is a temptation to say it's because we're special. It's because we are different. That we are given power or we are given a voice because of who we are, not what we stand for. And that's the line, right? I think we've all seen the video. It was a disturbing video. I think it was probably a year or so ago, when Mr. Brandt talked about guns and shooting people. It didn't happen. He didn't do it himself. And I think he made clear he wouldn't do it himself, but there was a sort of call to arms, a dangerous call to arms. And that moment right there, our case, those things, those are the moments where a man who was a warrior for the unseen began to feel like he deserved the power. It's the very thing he fought against. It's the very thing that got him to that position in the first place. And it's incredibly, profoundly human. There are police officers who believe that they get the power because they deserve the power, rather than we are stewards of power. We are briefly and temporarily holding a flame of power to protect other citizens. DAs struggle with it. There's a sort of group thing. Anyone who receives any measure of power struggles with that. And I think that this case is a reflection of that. I think this case is a reflection of a man who was unseen, who became angry, who fought back, who was a warrior for social justice, but let it go to his head. And so there's an argument, certainly. I'm not saying that there's not, and the court, it's sentencing is the court's purview. You could certainly incarcerate him. But the thing that I kind of go back to, and I think that over the last few days, in particular, I've gone back to, is this reflection on the Reconstruction era in American history. We don't have to, nor should we, gouge. We don't have to hobble a man to find justice here. We don't have to do that. We don't have to use the prison system in an answer to this conduct. The conduct is criminal. The conduct is human. The conduct can be corrected because we've identified at least an option for solving it. And so, from my personal perspective, I don't think a prison sentence is necessary. I don't think it's warranted. I don't think that we need to deepen distrust and hate. The country is more tribalistic than I've ever seen it. It's incredibly disappointing. And unless people stand up and walk toward the middle and say, I see you, I don't need to cancel you, I don't need to throw away the keys and throw you in prison, I don't need to defund these people, I recognize there are good people. Unless we all get somewhere where we can recognize the humanity in each other, I don't know how we move forward. And so that is my reason for not requesting a prison sentence in this state. The other thing I would point out, which I think the court would rightfully be concerned about, to the extent the court is aware, is the difference in. Now, I know defense attorneys oftentimes say, Judge, we can't consider that. And that's not true. Under a case called Benzer, Benzor, a case called Tall White Man, and I can get you all the citations for these. I have it on my laptop, but I can pull them up on my phone. The court can consider them. Not as convincing, certainly, not as proven, but the fact that there were police contact and the contact was for similar purposes, can. But what I would encourage us to do when you consider these pending cases, I think there might be 4, is also consider all of the dismissed cases. And I made a list of those cases, and I didn't know we were going to start so late, so I was actually going to read them. But I'm not going to do that now.
I'm sorry. I mean, just to get the story, I'm the first person. I read the entire report, and that was cases, so I'm familiar with it.
Okay. And so it's a very long report. And so when we consider the cases that are pending against Mr. Brandt, we should also consider all of the cases where he had to sit in a jail cell, he had to sit in a courtroom with corrosive anxiety and not know what was going to happen, and only by his courage to push the envelope did he walk out of that courtroom. And what he received was a monetary judgment for his time in custody, a monetary judgment for lost days and lost moments. And so I do think that both of those things are fairly considered together. With respect to the nature of the community sentence, I believe that the defense is going to ask for some sort of jail enclosed. I don't know if that's true. Okay. If that is the case, I deeply disagree with that. I will tell you, I don't think it is helpful to not have him under supervision. And here's the reason where I'm kind of drawing the line. It is human to fail. We try and we fail, and we try to get better and we fail, and we hope that every day maybe we're a little bit better than the day before. But people regret, people backslide. That's why we have recovery courts. We expect it and we work with it. I don't expect him to leave the courtroom and say, gee Willikers, I'm never going to do any of this again. It's going to be better now. I'm a whole person. There is a lot of hurt we have to heal. There's a lot, and it's going to take some time. And if he continues to threaten people, well, we might work ourselves into a pretty lengthy incarceration. But at this time, I think if we have him under supervision and we try to target those things in a community-based, I guess, situation, that is something I do agree with. The last thing I'll say, with respect to, I guess, the harm, the harm with this conduct, and I, part of it is for the court to hear, but part of it is for Mr. Brandt to hear. When we use words, as a lawyer, I'm not very good at math. Numbers don't mean a ton to me, but words matter. How they're said matters. How many times you say them matters. The feeling behind them matters. And Mr. Brandt may not have any intention to harm a fly, and I believe that. I do. I don't think he hurt anybody. But it doesn't matter. Because he has a platform, and he uses his words, and he's smart. And God forbid one person gets injured because he's mad and he throws a fit. I think they're fit. Again, due to the power issue. If one person is injured, you can't take that back. You gotta live with that for the rest of your life. And that family has to live with that person's take hold in their life. And that's not okay, and that's too big of a risk to take. And so, I'm happy to try treatment. I'm not asking the court or Mr. Brandt to not protest. But it's got to be done responsibly. Because every single person matters. Even if he thinks that they abuse power, like I think that he abused power in some of these posts, I'm not calling for lynching. I'm not calling for an incarcerated sentence. I'm listening. I try to listen to Mr. Brandt. I try to hear his hurt and hear his words. And I hope that this justice process, if we are honest and we are transparent and we are good and we are kind and we work hard and we fight, that maybe we can change lives. Not only for our sentence. My hope is that he sees that you don't have to respond to abuse of power with more power, with more money. And so that is why I am requesting a community-based sentence with an emphasis on mental health.
Well, let me ask, the community-based sentence, as far as I'm aware, the only option is probation, correct?
Yes, sir.
And are you requesting a specific length for probation?
I do think a lengthier term of probation is appropriate, and the hope is, at some point, probation becomes diminishing returns. It's very difficult for people without cars or without steady streams of income to comply with probation. So I'm not asking for a lengthy term with the idea that I'm going to hobble him in some way. My hope is that at some point, he may not need our supervision, and he can work with his probation officer and apply for early termination. And I'm not the DA that's going to object to object. I will hear him, I will see what he's done, I will look at his track record. And if he earns a way out early, I'm fine with that.
Well, all that's fine. I mean, it's to go from supervised on supervised. It could terminate early.
Right.
My question to you is, if you haven't, you can tell me what it is. If you don't, that's fine. But is it 3 years? Is it 4 years? Is it 2 years? Is it 10? What is it?
4 years.
4 years. Okay. And you're not asking for jail.
I'm not.
And let me kind of tie up a loose end as well. We have this other count. In this case, it has a 6-month jail sentence.
Yes.
That was suspended on the condition that he completes the deferred. Now, your motion, when you filed it, was not to impose that jail sentence. It was to revoke the deferred. Do you want that just hanging around out there, or what do you want to do with that?
So that was actually, candidly, I didn't recall that was hanging out there.
Well, I think it is, because it was on additional count 5. 6 months jail suspended upon successful completion of the conditions of the deferred. Now again, your motion didn't address it. I'm suggesting the bigger picture of the felony conviction here. On the other hand, and if you would want to just leave that alone, fine. I guess it's sitting there, possibly a motion you filed at a later time to impose it, although it's pretty clear, I've already found that the deferred was violated.
Right.
So, I'm not saying I'm looking to enforce it. I'm just saying, are you aware of that? What do you want to do about it?
I wasn't aware of that. You know, can I address that on my
Okay.
second one? So if I just talk sometimes, no one makes their best record.
Okay. All right. You want something else if you need to. Well, I guess you can't because you don't have your stop that. But
thank you. Just a little thought.
All right.
Helpful.
Mr. Kennedy, you can proceed whatever order you want to. Mr. Brandt, just so we're clear, you have the right to make a statement to the court. You're not required to. That is totally up to you. You have an absolute right, in addition to your attorney's argument and so forth, to make a statement if you want to. And again, in what order that occurs is usually something you and your attorney decide. Okay? Mr. Kennedy?
And Your Honor, I'm hoping the court has received the social work report I sent it back.
Mitigation report?
Yes.
Yeah, I read that. I read it like that originally, and I read that again this morning.
Thank you, Your Honor. Yes.
And let me just say right now, I'm going to say a lot about why a prison sentence is justified. I'm not going to sentence Mr. Brandt to prison. I don't know if that abbreviates your argument or not, but it's very, very rare when the people ask me to use the community-based sentence, and I said, you know what, I'm not going to do that. So, go ahead.
I will curtail my remarks. I think that's the guidance the court is giving me. We essentially joined in that request for a community sentence. My proposal to the court, if the court was inclined to impose some sort of intermediate sanctions between probation and DOC, which I think is our only other option here, would be to use some of that suspended sentence. I don't think the court is required to impose all of it pursuant to the Sierra case. But
On the count I just talked about.
correct. But I think the court could impose some amount of a county jail sentence as a condition of probation or relevant to either misdemeanor count in this case. As an in-home detention sentence was going to be my request of the court. And I also wanted to let the court know it's Mr. Brandt's request that the court impose probation, but add the condition of he has to meet with Mr. Mears, who I believe is calling in at least once a week. That's the therapist he's presently working with. He's a licensed clinical social worker based in Trinidad. I have a much longer argument, but that's essentially the nuts and bolts that we were joining in that request. He does have 31 days of pre-sentence credit that I calculated.
I guess we wait till at least address the 6-month sentence. But otherwise, no, I do think Mr. Brandt needs supervision. I think he needs to know that if he just can't finally bring his conduct into line here, that he's got this possible 6-year prison sentence. And I think that's important here. So if the idea of no, we're just going to, give you jail time, and I don't know what you're saying on the felony, then 90 days probation and terminates after 90 days in jail or something.
That's not my request.
Okay.
I'm asking for a supervised probationary term.
Okay.
I'm just suggesting if the court would like
I don't feel compelled to put him in jail. He's been in jail a lot. A punishment is certainly justified in this case. Again, I'll address that a little bit more in a minute. On the other hand, and even more so now during this pandemic, just go sit in jail for a while. I don't know what that adds to this thing. It doesn't add much more than
I thought the court might want to add some sort of sanction, so that's why I brought that up. That could be a compromise. I think
none of it asked for it. And as I said, I'm not bound by the people's request, but it's been very, very rare that I've said, you know what, I'm going to do something terribly different than the people who asked.
I understand the court's position. Mr. Brandt, I think, does wish to address the court. Mr. Moore and also Edward Harris, who is one of Mr. Brandt's other lawyers, should be on the phone. I gave them the number and asked them to mute themselves initially.
So, let me just add, one person is a counselor that you want to be a condition of this, and the other is an attorney in a case in Larimer County.
Correct.
And what would be the relevance of the sentencing of an attorney in Larimer County? He's also a civil attorney.
It's my understanding that the court is signaling to us that the court is likely to agree with Ms. Easton's sentencing request and not impose any additional jail. Given that, I'm not saying you need to call Mr. Mears.
Okay, you want to do that now? And I'm not sure when you say he's called in or he's in the queue. Let's just head to that. We'll figure that out in a minute. But Mr. Brandt's going to make his statement now. Go ahead.
Thank you, Your Honor. When my co-defendant everything. We're on with the Facebook post, people keep the role. Tell you that I immediately took the stance to take accountability for this post. It was under oath, that those are my actions, they were my actions. I've entered a plea on this case, and I think that there's two very important things that have come out of this case. Number one is, well, I'll say that the most global question is that Ms. Houston has always been my partner on this case. She was there for me when I turned myself into diversion. She worked with diversion with me, and I think that diversion was overall very successful for me. And when I filled out the packet for diversion, Mr. Moon and Ms. Houston were surprised that I had admitted to the program that I had a substance abuse. He is the icon of everything we want government to be. He truly has been. And if everybody would like Ms. Houston, then I would not have a government. So I wanted to, and it's important because I know a lot of people are watching this. And a lot of people look at me as, oh, he's going to go out and scream and fuck everybody. And that's not what I believe. And I think it's really important, not just for the court and the people to say that, but I think it's really important for everybody. Government works well when the people choose to participate in it. And Ms. Houston chose to participate. So everything that she said is the great bulk of it. And I appreciate that. And I would could have said that regardless of what school. But really, my and I took the word seriously. I did. I don't know how many hours of community service I did, but it was in the hundreds. I would have just paid off all my court costs today if the window were open. So I would pay all those that you paid, and I appreciate that. I didn't have to pay offenses. So I know she talked about receiving some monetary judgment. I don't think you guys understand how many bonds I have to pay. I still owe my bonds a lot. And what I want to talk a little bit about some of the successes too, that I don't think would have been possible without the perseverance and without the belief that there were people in the system that were there for all the right reasons. And she's not the only one, by the way. But if there's other people out there, I have made case law twice. And I'm honestly a little bit proud of that because I know attorneys salivate to do that. I made case law that it is in fact protected speech to distribute literature about criminals and people in the courthouse. And I am also the Brandt of Brandt versus Westminster, which you'll find strictly limits liability and total conduct with the fighting words and this is the point in the book. But that particular Brandt versus Westminster just finished after 7 years. So, and in the last, well, one was from the personal side of things, I admitted to using substance abuse treatment, misuse and to Mr. Moon, because it was time. I think this is what I said to at the time too. They were surprised. It was time. And it didn't happen overnight. I was not that anyway. That doesn't mean that I haven't used. But I haven't used in well over a year now. And it took a long time, and I had this new therapy to do that. I had to be online of sobriety to account. And the other day, very unfortunately, I went to the speaker den to get the rest of my belongings there today. And we can ignore it. I was not there for 5 minutes, but they were offering dope, and they were trying to sell me dope, and I wasn't going to do any of that. They were trying to borrow money from me. Most of my belongings were destroyed or gone, and I don't like to have fun for you. I really
abuse is not an issue. It's fine because I'm on one of this sobriety anyway, and in fact, I might, on our case or other days, I might not make it to the monitor to the you guys like I do have to you guys get some to do to affect that. If you want because I do have these days. But I think monitor sobriety was important for me, by the way. I don't think that I would have done it without it. And just to know this really good thing, then when I was in jail last year for like, what, 6 or 7 months, Jefferson County has a big for health bond. And I asked for that bond. And it normally takes like months to get over there, and I put me over there right away. I was there for all the 2 weeks of the time that I was there. And I was 100% compliant with the program. And then I get out of custody with COVID, and everything is completely screwed up. And so I ended up living out in Manzanola right now. I have a great support network. I have a place to be with the person trying to impose house arrest. Those people are wanting me to be there, and I want to be there. And it's great because it's really fun to speak to them, and it's really well with them. So I'm like, stay there, and there's just the police are basically there. But I have a great support network, and it's a clean support network. I'm very happy to have it. But one of the things that I didn't have was I didn't have my freedom. I didn't have that person to sound off of with independently. And you know what I mean? You know, I admitted to my drug abuse and my mental health questions, but I don't really want to court me on my dirty law. I think that's important. I needed a safe person. And so I actually have been engaged in private therapy with Glenn Mears. I came across him because thanks to a lawsuit that I won in Inglewood, in addition to a monetary compensation, by the way, I also got body cameras. That's an important thing for me. Return notifications, body cameras, that's immediately on my list. I secured my future by purchasing a property in Trinidad that I'm intending to develop. I just got my first permit the other day. So I have a safe place to go. I really want the court to let me go hide under my rock in the desert. I'd like to be able to move there soon, but I have to have that first. I have a car. I'll be paying off all my court costs so that I can get my driver's license back. And I'm engaged in treatment on my own, and the VA is not paying for that. And one of the things that was interesting when I saw Mr. Mears is that Mr. Mears is a counselor and a board member of the Trinidad Mental Health Court. So he has a perspective that's very compatible with the kind of treatment that I think I need, and it's very compatible with my goals in life. And he gets it, right? And that's important. Because my last therapist was all right, but she didn't get it like this guy gets it. And I'm really pleased with this. And that's something that, because I can't just go to the VA right now, I have been paying for that out of my own pocket. And I'll continue to do that. And I've been in therapy with him once a week since August, late August. And I think that I've come a long way. I think that he's helped me be a little less angry. I don't think it's inappropriate to be angry, but I'm feeling a little better. So, I think it's important that we all hear the things that are working well, not just with me, but with the system. I try to be very respectful to the court. The court's always been very respectful to me. I don't think that anybody gets questions, even I think having to therapy. I think we get along. Yeah, so, I have never even been so much verbally disciplined in jail, and I think that there's a pathway, there's a roadway here, and I want to also let the court know that I've been working. I'm the one that broke the ketamine story out of Lakewood, Colorado. Like McCormick story, just a white guy, nobody cares about it. But and he lives. That's another reason I don't know about it. But I broke that story, and that has been on 60 Minutes now. I've been working with our clinical psychiatric pharmacist by the name of Dr. Portman, who called the letter in the pocket. I've been working with Councilwoman Anita Spring, who unfortunately couldn't. Both of them wanted to speak today, but couldn't. And we've been working with Representative Herod, and we have legislation on Capitol Hill right now
causes memory ablation, which restricts the narrative specificity. And so we think it's a very dangerous drug to be using. And so when I participate positively with council meetings, I've been recognized in local city council by city leaders. And I'm working with this, ketamine team. I think that I've found a way to use my power, if you want to call it that. I don't really think I have all that power, but to use my power in ways that are contributing to our community so that hopefully our children can inherit a system that at least knows we're following when we die. And so those are the things that I wanted to say. And I just want to end by repeating how great this people system really has been. And also say that I've been completely satisfied with my attorney's representation. I do think that she's fantastic. She has fought some things that I would have just given into because she thinks it's important for the system to go through all the motions. And I know that Ms. Houston understands that. Because we would see some processes here that maybe people are irritated about, but I think it's important to do. And I think that she is fantastic. That's all I want to say. I want to ask the court to allow me the opportunity to continue this positive progress that I'm making.
Thank you. Thank you. And so let me just talk about Mr. Mayor. First of all, I assume you're going to ask every probation transferred to that town in your supervision, because that's where you're living now.
I don't know what probation will look like or how much. It is 4 hours away. I'm currently living in Crowley County. As a matter of fact, when I look out the door, if I look that way, I see the Woodland prison, and if I look that way, I see the Crowley prison. But I'm thinking that I'm probably going to be able to go over.
We're not going to resolve that today. I'm just asking that, in other words, most people, some people, don't want to be coming here to programming it, but I guess have to do another county. So, and I guess somewhere incumbent in that is that if you're meeting with Mr. Mears, that you're probably going to be in that community. Is that what you're saying?
I would say that. I would say I'm not allowed to live on my property until I have a septic system. So I've begun that process, but I'm probably not going to be able to actually live on my property until spring.
So Mr. Mears is in what?
He is in Trinidad.
He's in Trinidad.
So I'm currently living in Crowley County, so if it's possible to... I don't know what the intensity is. If we're doing most things by remote anyway, then then it's important to move it down to accomplish this. And I guess
and Mr. King, let me ask you then. Ms. Houston has said, well, we should get the mental health evaluation in treatment. I don't know if she agrees, but I just say he doesn't need to be evaluated. Mr. Mears is adequate. Is that what your request is? Okay. Okay. All right. Position, then any rebuttal and or addressing the 6-month jail sentence?
I don't have any rebuttal. I'm glad that Mr. Brandt talked about all the things that were going right. I think I wouldn't have any access to a lot of that information. I'm not sure that the court would. But I'm glad to hear that he's still trying to make the community better by working with legislators on things. I think that that's great. It just you can't be threatening when you do it. You can't put other people at risk, is my only. With respect to the jail sentence, I'm not asking for that to be imposed. What I'd ask is that the court, it's maintained on the minimus. There's pre-sentence confinement credit that's available. And if we have to come back and look at an interpretive alternative, then I think we can impose it at that time. Ultimately, understanding it's up to the court, what the court chooses to do.
Let me just make sure I understand that so the record's clear. On the one hand, that could mean, well, it's been determined that Mr. Brandt did not complete the sentence of his deferred sentence. Therefore, that sentence could be imposed now or at a later time. Or, I guess you should ask me to modify that the conditions of the suspension of that sentence to now comply with this probation sentence. And I'm not trying to steer you or that. I just think we need to be clear about that.
The second option, the latter, amending it to specifically, rather than compliance with the DJ, compliance with the probationary term.
Very good into that. All right, the court makes the following findings and orders concerning the sentencing. And again, I think I made clear where I'm headed here, but I think it's also important to say some of this for the record. The sentence originally charged with 3 counts of contempt to influence a public servant. One was Judge Delgado, another one was a social worker, Mr. Anderson, and a third count of retaliation against the judge, the victim being Judge Delgado. Those are all Class 4 felonies. And the defendant originally pled not guilty and set those matters for trial, but eventually then he chose to enter a guilty plea to count 1, attempt to influence the public servant, that being Judge Delgado, and counts 2 and 3 were dismissed. Additional count 5, obstructing governmental operations, so his guilty plea to that involved a 6-month suspended jail sentence. And then additional count 6 about interference in school operation where there was a fine imposed. Again, the conditions were for the deferred sentence. And again, this was a very good offer to him, gave him an opportunity to successfully comply with that, and if so, then withdraw his guilty plea. But he had a 3-year deferred sentence with a number of conditions that he was dissatisfied. Motion was filed about a year after he entered that plea, asking requesting the court to revoke the deferred sentence based on several criminal convictions. The court found that those convictions did occur. He had violated the terms, and again, that's this matter for sentencing. So, considerations for sentencing, and both counsel have touched on most of those. But first we have to consider what is the offense here, and as Ms. Easton has said, this is attempt to influence Judge Delgado, who is a public servant. She's a district court judge. At this particular time, she was presiding over a child dependency and neglect case. And again, the elements of that offense will include by threat of violence against her person or property, and with the intent to alter or affect that judge's decision or action concerning that case. So, again, that was all discussed at the time. The defendant pled guilty to that. That is the offense. It's a serious offense. As noted by Ms. Easton, and obviously this court agrees with the judge, the court understands that persons, whether it's the persons involved in the case or others, are often unhappy with a particular case, or the case has been filed, or the outcome of the case, or what the sentence is, or whether it's the person I've read the mitigation report. I've read the three-sentence report in the other case that was used in this case. We don't need to belabor your entire history, Mr. Brandt. I think what he said has outlined a good deal of it, and probably accurately. You had difficulties. A lot of people do. How you deal with them, that's why people are often in court. Up to, looks like, somewhere around 2011 or 12, you weren't in the court system with any regularity. Again, at some point, your way of approaching what you saw as injustice and how you're going to shift the balance of power and so forth changed. And it, first of all, became demonstrations and so forth, and it escalated into this sort of behavior. This behavior, meaning, again, this is done, I think, on a Facebook page or your YouTube at the time of this particular case. And so obviously, whether, it was a mental health issue, it was substance abuse, it was, the influence of others, I don't know. But the bottom line is, it was a road that got you into a lot of history with the court. There are many convictions here. There are many cases dismissed, no doubt about it. There are many convictions as well. They are all misdemeanors up to the time of this case. That doesn't mean that's a good thing. I mean, some of them are for things like third-degree assault or trespass and so forth. But that is your criminal history. There's no doubt about it. It's a long criminal history. And what I'm hearing today from not only Ms. Easton but you, and I will say again, Ms. Easton has been as much of an advocate for you as any prosecutor I have ever seen in the case. She's been extremely fair, and I think that's a good thing. As you noted, I don't know that every prosecutor has to deal with the case that way in order to be a good and fair prosecutor. I think she's done well beyond that, but she's tried as hard as she could to be fair to you, to recognize why you're in the court system. Are there better ways to treat your situation than simply putting you in jail? And I agree with her about some of that, although, again, I also have to look at the fact that the pre-sentence report that was filed in this case, I think it would have fit in the Jefferson County case was a message, and I guess that's why that said give you a jail sentence. I know it's on appeal in the district court there or whatever, but they weren't real optimistic about your ability to be supervised in the neighborhood, that you wouldn't do the same sort of criminal behavior again. I have to assume that's why, instead of putting on probation, that's what that judge did. I don't have to agree with that judge, but that's what probation was saying there.
I can tell you what his reason was.
Well, no, I don't. We don't need to get into that. But the bottom line is, one of the things the court is to consider is rehabilitation. Can the person be rehabilitated? And I can't say how many times, Mr. Brandt, I've had defendants appear in front of me and say, Judge, I'm a new person, and you won't see me here again. And many times I don't see them again, but they don't all succeed. And quite frankly, people are inclined to tell the court anything it takes if they think will avoid a severe sanction, like a prison sentence. I'm not saying that's you. It's just what I'm saying is, the only person who really knows if you can alter your behavior is you. So these things, she looked into your situation, she believes that's the case, but she can't change your behavior. When I say change your behavior, meaning it cannot escalate to this kind of level of felony against judges and public servants. That's different than I'm standing in a protest for the sign, or I'm saying something to exercise my right of free speech that doesn't cross the line to a threat against someone. So, Ms. Easton believes that probation supervision, certain conditions of that will work for you. I'm willing to go along, and I hope we're all right, because as she says, none of us wants a situation where you inflame somebody else. Your rhetoric may be something you don't intend to carry out anyway. But there's other people out there who aren't as smart as you do, who don't think the same way as you do. hear this, and they go off and carry out those kinds of things. That is a huge danger with this. And this is far different than making a statement directly to someone. All you do is walk up to the judge, for instance, and say, I think you should have this done. Well, that's far different than going out in a public forum and saying that to other people to get them riled up and so forth, because now we've brought all them in as possible perpetrators. Of course, consider punishment. There's no question that punishment would be warranted for this. I'm not going to punish you, but it would be warranted, just to make clear for the record that that's the case. And why? Well, one, it's a class 4 felony. It's not a misdemeanor. Two, again, if you look at this, there's a lot of probation sentences, a lot of jail, and so forth. And again, the question becomes, at what point do we have to increase the punishment to get something across? When I say get something across, it does two things. One is the public safety issue. To remove you from the public, well, at least during that period of time, you can't be doing harm to somebody. Secondly, there's a deterrent effect, hopefully for you and others, if we say, you know, if you do this, what happens is there's a severe punishment for that. And, I mean, again, this offense does justify this. I have no idea what will happen in your other cases, whether you will be convicted, whether it's pleased, what other judges do. I can only deal with this case here. The reason I'm willing to go along with this sentence is, I think I made clear to you before, and why I continue this, and said, look at Veterans Court, look at other. I don't think prison accomplishes much of anything other than removing you from the public so you can't harm people during that period of time, punishing you, and maybe sending a deterrent message to others. And those are important, but it's very seldom rehabilitating an individual. And there are better ways to do that. And you seem to be committed to that. You're getting counseling. You're saying you're removing yourself to more remote locations. Maybe you don't get tied up with the same individuals or the same kind of thing. Well, I think that'd be a good thing for you, because this is all down the front range, where these cases are. And again, that's why we're here in this case. So, having considered those factors, I do think an appropriate sentence is a probation sentence. I do think it should be fairly lengthy, 4 years. And again, the reason is that, if you can't succeed on this, I'm not saying that has to be your sentence, or it's predetermined that you go to prison. But again, we're going to run out of options here. You cannot, stay in the community, be supervised, and remain law-abiding. So that's the standard condition for the probation sentence. So I think the case, an outline situation from the probation department saying exactly what we think Mr. Brandt needs to follow. But I don't think there's any question that you need mental health counseling. Whether that's done by Mr. Mears or someone else, I don't know, Mr. Mears could become disabled, lose his state, who knows. But I'm going to order you to continue with Mr. Mears or someone else acceptable to the probation department, whatever probation department is supervising you at that time. Ms. Houston, you were not asking for any kind of substance abuse evaluation. So, such evaluation or treatment as they may deem necessary. Okay. It is so ordered, which means I'm going to leave that probation, because they haven't a chance to advise you here and say, go down that, or we've assessed this, or we talked to this counselor from meth addiction, or whatever it was, standard conditions. You either need to be employed, or looking for a job, or in school, or to the extent of your disability. Those are all ideas,
disability compensation.
I understand. I don't know if that means you're totally disabled and can't work, but the bottom line is probation. That is one of the things people are supposed to be doing who are on probation. And for a number of reasons, including the fact that too much idle time often gets people in trouble for one reason or another. On the other hand, if they determine that isn't reasonable anything in this case is prior to 49 days from today's date. And you discuss that with the lawyer if you want to. And if it can be, if you wish to appeal and that's not you going to do it, you need to file for a motion to report. Anything else from the people? Anything else from the staff? Thank you. Hold on just a second here.
So this report to the probation department down below the parking lot?
That's exactly what I'm asking the person about now about business what was going on over here. Okay, so you have you signed, yes, sir, the document, and you just heard what she said about you finally have students report to them. Yes. And again, if you want to take that supervision transferring to another county, you take that up with probation officer. It's not something that requires.
And you are authorizing transfer to another county?
I am authorizing, assuming that, assuming that other county agrees. You still live in some remote county that, we're not really prepared to handle this at all.
Nobody's particularly prepared to handle that.
Well, or during COVID or whatever it might be. But the bottom line is that's an inter-county probation decision that I have no objection.
Would it in any way surprise you to learn that I was at a gas station in Crowley County and there was an unmarked law enforcement truck at the gas station, and the guy came around his truck and I wasn't even dressed in my stuff, and he said, "Hey, Mr. Brandt, how are you doing?" It was Ordway County.
I suspect there's law enforcement people who might know who you are. Hopefully in the future that will be any positive days. But in any event, anything else from the people? Anything else from the state?
I need to ask, maybe my lawyer needs to ask this question, but I do have APUA today, and considering the time of the day and how far I have to drive to do it, I'm not sure I'm going to be able to complete that. And I don't want
This is a bond condition in your other case?
This is a bond condition in my other case, and my number was picked.
Your color came up today?
It did.
Okay.
It'll be my first year of this month.
Well, we don't have the district attorney here in that case, but ultimately that decision is up to me. I will waive your requirement that you do that today.
I will try, but I appreciate you doing it.
In case I'm looking for but obviously next time your color comes up, you need to do that.
Absolutely.
Rex, do you do that here?
Well, I've been doing it in Pueblo, which, by the way, is about a 2.5 hour drive.
Well, I guess this
I would have to try to find out where to do it here. And
right, I mean, this gets back to managerial probation supervision, the pre-trial supervision. Well, if you're living somewhere else, they need to get someplace closer to where they are.
that's what they did. They gave me Pueblo. It's supposed to be.
Okay.
My other one would be Trinidad.
Okay.
But what I'm saying right now is actually farther to go to Trinidad and back in Pueblo. I don't actually know where I would UA there, and I have to figure that out.
Well, this Brand, you and I be seeing each other in every case, but I sincerely wish you the best for us as far as the chief proceeding on this. Thank you, Ron. For the adjourned.
You keep an eye on everybody said. About you. Please stay where you're at. The world is